Hello, I'm Bill Curtis. This video and the Serving Our Seniors program will teach you about wills. We'll talk about what a will is, what happens if you die without a will, why a will is important, how a will is created, when a will becomes effective, and the differences between a will, a power of attorney for property, and living wills. Your last will and testament, commonly known as your will, is a written legal document that describes how you want your estate distributed upon your death. Your estate consists of the money, real estate, and personal property you own at the time of your death, after any debts have been paid. Not everyone who passes away has a will. If you pass away without a will, it is called dying intestate. If you die without a will, your state's laws dictate how your estate will be divided and distributed. Usually, state law divides your property along marital and familial lines. Each state's laws about intestate distribution are different. A commonly held misconception is that if you die without a will, the government automatically takes all your property. This is not true. Your property escheats, meaning it goes to the state only if there are no members of your immediate or extended family to claim your property. By writing a will, you give written instructions and specify to whom you want to give your property upon your death. Through a will, you can decide to leave property to your family, friends, your favorite charity, or to anyone else. Remember, if you choose not to execute a will, your state's laws determine the distribution of your property, and you may not agree with how the state will divide your estate. Depending on your life circumstances, a will may be a critical planning tool. For example, if you're married, but separated from your spouse, if you're divorced, or if you're part of an unmarried or same-sex couple, a will may offer you extra protection that your intentions will be followed upon your death. Your will only controls the distribution of property considered part of your probate estate. Certain types of property have other rules that control the transfer of ownership between people. As a result, your will cannot control who gets that property upon your death, because the property passes outside of your will. Examples of property that passes outside of a will include joint bank accounts, property owned in joint tenancy, payable upon death accounts, pensions with a named beneficiary, and life insurance policies with a named beneficiary. Because these types of property include a designation that identifies who should own it upon your death, the terms of your will do not apply. The requirements for a will to be valid vary from state to state, so we will talk generally about the basic parts found in most wills. Generally, wills must be in writing and signed. The person who signs a will is called the testator. For a will to be valid, the testator must be at least 18 years old and be of sound mind, which means having the mental ability to understand and make decisions. There are no standard written forms for you to use in writing your will. There is also no requirement that your estate be worth a certain amount of money. As long as you follow your state's rules about wills, your will should be valid. The most important language for you to include in your will is a sentence that states, "Your current will revokes any and all previous wills." This language is important because you can only have one valid will at a time. If you do not revoke your previous will, there could be inconsistencies between your two wills and potential problems about how to divide your estate. As part of your will, you can name a specific person to carry out the provisions of your will. This person is called an executor or personal representative, depending on your state. The executor's job is to ensure your will's instructions are followed. The administration of a will can be time-consuming and involved, so be sure your executor is someone you trust and believe will do a good job. You do not need to list out specific items to pass on to certain people named in your will. If you choose to do so, however, be sure to identify the item in enough detail to distinguish it from other similar items to avoid any confusion. The signing requirements for a will vary greatly, depending on the state where you live. As a general rule, you must have what is called a testamentary capacity for your will to be valid. Testamentary capacity means when signing your will, you must possess the mental capacity to understand and make decisions about your will. Most states require someone to witness your signature on your will. Your state's law determines the number of witnesses needed and who may serve as a witness. In addition, some states require a will to be notarized. The rules on revocation vary greatly between states, and any questions should be directed to an estate planning attorney in the state where the will is to be written. Creating a simple will to distribute your property may not be the best course of action for everyone. Depending on your life circumstances, documents that are more complex than a simple will may be required to handle your estate properly. For example, if you own significant real estate or personal property, have concerns about personal and tax liability, need to plan for the cost of nursing and home care, have a child with disabilities, or will need to qualify for Medicaid, you may need further assistance from an estate planning attorney to learn about all your available options. We want to remind you that the videos in the Serving Our Seniors program are not intended to provide you with legal advice specific to your situation. If you would like to talk to a lawyer, you may contact your local legal aid office or bar association for more assistance. We hope this video helped you understand how a will works and how it can be a valuable planning tool for distributing your property after your death. If you do decide to create a will, it's a good idea to provide a copy to your family members and your executor, also known in some states as your personal representative.